We've only got a minute to go to 1 o'clock. Let's start early. I was going to say after that security announcement, doors to manual, cross-check. Well, good afternoon, ladies and gentlemen. Welcome to today's event at what is the 8th Festival of Politics and the 4th year that the Law Society of Scotland has had the pleasure of being a festival partner. My name's Austin Lafferty, and I am the President of the Law Society of Scotland. Today's debate will be looking at what could be done to improve our justice system, that's all. And our 4 expert panellists will put forward their views on the one thing that they would do in order to achieve that. And most importantly, you, our audience, get to have your say well, we have a live voting system. It was to be electronic, but somebody hasn't put the shilling in the meter. So our electronic voting system is the electronic system of your body going like that when we come to the voting. However, that makes you participate in a much more physical way than otherwise, so I hope you appreciate that. Let me first of all introduce my panellists, because what will happen is they will each speak for 5 minutes, and then we will have a general question and answer, debate, discussion. I was going to say free-for-all, but maybe not quite as bad as that. And by the way, this is the 3rd year I've done this in this room, presented this, and I'm just wondering what this middle space is for. It was occurring to me that if we don't actually get agreement by way of argument, then we each nominate a champion who goes into the centre and fights it out. Anyway, let me introduce our esteemed panel. Brandon Malone is chairman of the Scottish Arbitration Centre and is a partner at McClure Naismith Solicitors. He is a solicitor advocate and an accredited specialist in the law of arbitration. He's the chairman of the Scottish Arbitration Centre, as I say, a joint venture of the Scottish Government and the Scottish professions, which exists to promote arbitration to Scottish businesses and beyond, and indeed promote Scotland to the world as a place to arbitrate. Brandon lectures on arbitration and dispute resolution topics at the Universities of Edinburgh, Strathclyde and Dundee. But more importantly than that, when I was down in London a few months ago, he lent me an office to work in for the day, so he's a pal of mine. Brandon will be arguing for more arbitration and mediation as a way of resolving disputes. Susan-McPhee is Director of External Affairs at Citizens Advice Scotland. And Susan's been with the Scottish CAB service for over 20 years, presumably from the age of 3. Her current remit covers CAS's external relations strategy, including parliamentary and media liaison, national social policy work, as well as providing an overview of their external services. And Susan will be arguing for the law to be made less legal. It's an interesting concept, and I look forward to hearing about that. On my far right, Mark Thorley, a partner with Thorley Stevenson, is the vice convener of the Law Society of Scotland's a civil legal aid team. He's been a solicitor in private practice for over 20 years, dealing mainly in family work, and has been heavily involved in the civil legal aid system throughout that time. He's a former Law Society Council member and currently, as I say, vice convener of the civil legal aid team at the Society. Mark will be arguing for improved access to justice through increased access to and awareness of civil legal aid. On my immediate right, John Scott QC, who's a partner with Capital Defence Lawyers in Leith. John has been a solicitor for 25 years and was appointed QC Solicitor Advocate in 2011. He has been chair of the Howard League for Penal Reform in Scotland since 2006 and was chair of the Scottish Human Rights Centre, formerly the Scottish Council for Civil Liberties, from 1997 until 2005. John is a regular talking head, as we call ourselves, on TV and in newspapers on human rights and criminal justice matters. He will be looking at how human rights law is interpreted and viewed in Scotland. So there we are. Without further ado, can I ask Brandon Malone to open the debate by arguing for more arbitration and mediation?
Thank you, Austin. Hello, ladies and gentlemen. Ladies and gentlemen, I have a problem, and I'm sorry to say that the problem is sexual in nature. You see, I'm here to argue for reform of civil procedure, increased use of a different kind of civil procedure, and that's simply not politically sexy. It doesn't have much in the way of what you might call tabloid appeal. If you look at some of the other speakers making the law less legal, that means we might need fewer lawyers, we might need to give lawyers less money, And lawyer bashing is, of course, very politically sexy. It has a lot of tabloid appeal. If we were to extend that metaphor, it might be on, say, page 9 or 10 of our tabloid paper, perhaps like, I don't know, a shoplifting celebrity or something of that nature. What about civil legal aid? Well, that's people being denied access to justice. Lawyers refusing to work if they don't get paid enough. Ooh, that's, again, very politically sexy. If we look at our tabloid, it's like page 5, maybe like an unfaithful politician or something of that nature. Human rights, slopping out, sky sports and conjugal visits for prisoners. How much more sexy can you get than that in political terms? That's page 2 material. It's like a Peter, Andre and Jordan reunion, or perhaps a Brad Pitt love child. And against all of that, ladies and gentlemen, I'm asking that we should try and resolve our disputes using a different method of dispute resolution. If that makes it into our tabloid at all, it's back on page 49 or so, along with the adverts for teeth whitening and used caravans. Now, at this point, you're probably feeling very sorry for me, and perhaps you think you might vote for me just out of that sympathy. And I don't wish to discourage that for one moment, ladies and gentlemen. But there are, in fact, other reasons that you should be voting for this, and I'll tell you about it. Well, how do I persuade you that actually this arbitration mediation is politically sexy and that you should vote for it? Well, it's all about money. It's all about money, and what's more sexy than money after all? Now, when parties enter into a contract, they've got a choice. If they fall out, they can settle their disputes by mediation and arbitration, some other method. But if they don't specify anything, they go to court. Now, if you don't know about it, mediation is essentially an assisted negotiation. You get someone helping you to resolve your dispute. And arbitration, on the other hand, is where parties agree that a third party, who is not a judge, is going to resolve that dispute in private behind closed doors. So what if everyone mediated their disputes instead of going to court? Well, everyone mediated, there'd be a massive drop in demand on the court time created by civil disputes. There'd be a large drop in the amount of money spent by companies and individuals on lawyers. There'd be a massive increase in general levels of peace, love, and understanding. Mediation is a good thing, and it is not used often enough. But of course, mediation isn't suitable for every dispute. Sometimes parties don't want to settle. They want to have the day in court, or the equivalent. They want justice. And in those circumstances, parties tend to default to court because that's what you do. You sue people. But what if instead everyone went to arbitration? What if that became the norm? Well, again, you would have a massive drop in the amount of civil business going through the courts, and that would free up court time and resources. You'd have much less pressure on the appeal courts because, unlike in civil litigation, there's no automatic right of appeal. You have a quality filter making sure only sensible appeals get through. You had a massive increase in work for arbitrators, and that doesn't, of course, necessarily mean lawyers, because anyone can be an arbitrator and anyone can represent a party to an arbitration. So if you want to talk about opening up the law and increasing access to justice, then that's one very obvious and clear route. So if everyone started using arbitration, we would need more arbitrators, and these individuals would be doing work currently done by judges, freeing up the judges to deal with matters that can't be arbitrated, criminal work, matrimonial disputes involving children, immigration, that kind of thing. But better than that, if we can firmly establish a culture of arbitration in Scotland, we can start attracting international arbitration to Scotland. And that's not just legal fees. If you can imagine a dozen lawyers descending on Edinburgh for a 3-week hearing in a multi-million-pound dispute, think about how much money they're going to spend on taxis, and restaurants, and hotels, and nightclubs. I could go on. Brain yourselves in. Multiply that by hundreds of disputes per year, and what we're talking about here is creating a new industry with all the spin-off benefits that a new industry brings. In London, it's estimated that the value of their international dispute resolution business, which is, of course, very mature and very well developed, is worth £250 million a year. And the value of that type of business internationally is more or less incalculable. And we should have a share of that in Scotland. We should bring that here. And as we gain expertise, so we can export that expertise and further increase the tax revenues for our professionals working abroad in this area, it's a virtuous circle. So real jobs, real money, a huge boost to our economy, and all in a time of recession. That's the ideal. And the benefits don't stop there. By taking pressures away from courts, there are savings to the public purse. The money can be reinvested in the justice system, so there are additional resources for civil legal aid, perhaps, for the Law Commission to simplify our law perhaps, to increased funding for citizens' advice, for additional funding for high-definition televisions and jails and other fundamental human rights. So, ladies and gentlemen, I put it to you that arbitration and mediation are politically sexy. And if we return to our tabloid metaphor, it doesn't belong back on page 49 with the caravan adverts. No, in fact, it's better than that. It's not even an unfaithful politician or a Spice Girls reunion. It is, in fact, a naked prince. You had no idea the trouble I had to go to get that photograph. The planning that went into that. Anyway, ladies and I had another funny ending to that, but I mean, you can't pass that up, can you? Ladies and gentlemen, it's possible that I've taken my metaphor too far. But I hope that you'll take my point that increasing arbitration and mediation is not just the best way to improve the justice system, but it offers strong benefits to the economy as well, and might just allow us to invest in the other options that we're going to hear about today. So I urge you to cast your vote for increased arbitration and mediation. Thank you.
Thanks very much, Brandon. Thank you very much for joining us on Planet Earth from the planet Metaphor, where you've been for a while. Right, Susan, would you like to tell us why the law should be made less legal?
Okay. Right. Well, what's the law? Well, to me, law are the rules that govern our society, and they're the code that we're expected to abide by. So I've always wondered then, why is that code so often impenetrable and unknown to so many of us? Because too often we don't know what these rules are, or else we don't understand them because of the language used to describe them. But the consequences of not knowing or not understanding these rules can be severe, because they can range from imprisonment for possibly a serious breach of these rules, but they can also result in homelessness, poverty, unemployment, and even in today's day and age, hunger. So to my mind, there's a number of reasons why many of us don't understand them. Firstly, there's lots and lots of them, made by different forums, such as the European Parliament, Westminster, Scottish Parliament, and there's different types of laws too, such as Acts of Parliament and statutory instruments. So to me, it's no wonder why many people find the whole structure of law confusing and very alienating. And it's not just the number, language, and type of laws that are made that disenfranchise people, because there's also overlapping complexities between the different decision-making bodies. For example, in the Citizens Advice Bureau service, we have to write UK law into plain English, we have to adapt UK-wide statutes for the Scottish applicability, as well as rewrite Scottish-only legislation into something meaningful and understandable. And then on top of that, there's the changing environment within the courts and tribunals, and the issues of laws devolved to Holyrood, reserved to Westminster, and all of these grey areas in between. So as a basic principle then, why are our rules so complex? Because isn't it odd that if our laws are the framework of our society, then in order to understand them, we have to have them interpreted to us by others, whether that's lawyers or cab advisors or anybody else. Because surely one of the fundamental principles of a society is that we understand and we accept these rules that govern us. Because if we're alienated from them, or we don't know what they are, then what sort of society do we have? It's not only the laws themselves that confuse and bewilder most of us, because it's also the forums where laws are challenged and enforced that can often be intimidating. And I don't have time to go into that here, but I think that while resolving disputes is important, we need to start way before that, because often the disenfranchisement occurs much earlier because people don't know what their rights or their responsibilities are to begin with. So then, what do we need to do? And basically, we need to simplify the law and make it easily accessible. So while education plays a part through schools, universities, colleges, we need to do much more than just educate people about how the law is made. Because understanding the law is the key. Because understanding then opens the doors to these rules. And if you can open that door, then people can challenge them, enforce their rights, and engage with them. So the law needs to be translated, always. But also, people need to be told about them. A little point in laws being designed to protect people if the people it's designed to protect either don't know about them or else they can't use them. And we kind of have done this because, for example, the anti-smoking law, that's widely known. National minimum wage legislation, that's allowed the concept of a basic wage to seep into our public consciousness. So for me, then, key pieces of law need to be written in an easy way and promoted extensively so that those who need to know are made aware of them. So as a starting point, every piece of law should be accompanied by an easy-to-understand translation in plain English and a communication strategy. Because let's face it, if it can't be written into plain English and easily communicated, then probably it shouldn't be there at all. But I think we can do more than that. Advice guide is a very simplistic translation on the law on the web currently, and the statutes are also readily available. But we need something in between, like a user's guide to the law. So I think we need to put some money into developing a web-based law for dummies, if you like. A simple, expanded version of advice guide that's more than just basic knowledge, accompanied by self-help tools that you can do yourself. So it's about a readily understandable guide as to what to do that will support people to understand their rights and with templates for how to enforce them. And these kind of things have been done in certain areas before, and they do work, because most people are aware of what the rights are about defective goods, for example. We just need to do much more of this across more areas. So that then leads to the situation that not everyone's got access to the web. So we need to have an access point with free, easy-to-use booths so people know where to go to look at what they need. But even if the law is made accessible in terms of understanding it, they continue to be exploited. So it's not enough to just make the law and explain it. People need to be given the opportunities to challenge it and use it to make it work. So if you take employment rights, it's extremely difficult for an individual to challenge a large organisation or an ordinary employer. Because if you're under 25, you've got your first job in ages, you're working in a pub or a kitchen, and your rights are being abused, you're not going to challenge it even if you know that they're wrong. So we need the state involved in protecting citizens where there's an imbalance to ensure that rights are enshrined in legislation that are not abused. So for example, if you use the Low Pay Commission, that helped in ensuring national minimum wage was enforced, and we need more organisations like that, particularly in employment. So I would argue for more state commissions who will intervene, starting with a Fair Employment Commission. Finally, I accept that rights aren't always straightforward, and they can be more subtle, where you need interpretation and representation. But I would ask, why can't we start with a straightforward approach to simplify the key laws, promoting them and allowing people easy access to use them themselves? So just in summary, what I would like to see is all key pieces of law to be accompanied by a plain English translation and a communication strategy, a web-based law for dummies to be accompanied by basic self-help tools, free, easy-to-use, readily accessible booths to access the law, and state commissions to help you enforce your rights, starting with a Fair Employment Commission. Thanks very much.
Yes, thank you, Susan. I just remember when I was doing my weekly legal phone-ins, I suppose I was the free, easy-to-use booth that you're talking about. Thank you. Let us move on to Mark Thorley. Mark, tell us what your views are on improving access to justice through increased access to and awareness of civil legal aid.
Thank you very much. Good afternoon, ladies and gentlemen. Access to justice is the cornerstone of the modern democratic society. We hear that very often, but how in practice do members of the public actually get access to justice? We can have, and some people may say, we have the finest justice system in the whole world, but if people can't use it, then it becomes functionless. It's easy to imagine how many cases, as a lawyer, are going through courts. There are clearly many criminal cases going through courts where people's liberties have been affected on a daily basis. But there's a whole raft of civil cases that we see going through courts. And if I could say to you that this can stretch from people being evicted from their homes repossessed, people fleeing domestic violence, people seeking recompense for having been unfairly dismissed at work, those people who have been injured potentially at work. There is a vast array of areas of law in which people are required to be helped. But how do you obtain the access to the justice that you need? It's fairly simple that if you can pay for it, you'll get it. But if you can't pay for it, how do you get it? And that's where the legal aid system helps people seeking access to justice. It may surprise many people to actually find out that the legal aid system, as we know it now, was only introduced into Scotland in 1950. Up until then, there had been the wonderfully created PORS role, which, as I'd looked back in time, had in fact been created in 1424. So for over 500 years, Scottish lawyers and Scottish advocates gave of their advice free. Now, that may have worked when there were very few people being represented. The High Court wasn't being used as often as it does, and the amount of civil cases that we have now is not to the extent that it is. But unfortunately, that cannot continue and did not continue beyond 1950. It's also important probably to say as well at this point in time, I'm sorry, and I do apologise to Brandon, I'm not cracking many jokes here because civil legal aid, as far as I'm concerned, is not a joke. There are two types of legal aid. There's the civil and the criminal. There's the court-based legal aid, where you obtain legal aid to go to court to represent someone. And there's the legal aid, which is for simply seeing somebody and trying to represent their interests without going to court. But in 1952, which was the first year in which legal aid scheme was actually in place, there were 4,400 grants of civil legal assistance. We now compare that to last year's figures. In 2010 to 2011, there were 90,000 grants of civil advice and assistance, 13,000 grants of civil legal aid, and that does not count the 150,000 grants of criminal legal assistance. That is approaching 250,000 people or cases in which lawyers have been involved either before or either in front of or are out with the courts. When we consider Scotland's population, that is a huge amount of people who have been seeking or obtaining a representation in many ways. And I suspect that there are many, many more people who have not been able to obtain legal aid, who clearly require it and who clearly need it for a case that is important to them. And that is the whole point. People's cases are important to them, whether it be a neighbour who is causing their life hell from downstairs, or whether they simply have had to leave the domestic home, taking the children, they've got nowhere else to go, they need help. And that's where we need in Scotland to have the most robust civil and criminal legal aid system that we can possibly financially provide in these straitened times. We need to focus our legal aid system on the people that need it. We do need to make sure that we are robust insofar as the right people get the right help here. But unless we fund a system properly, that is where our democratic society falls down. We need to have access to the courts. Going to court, of course, is always a last resort as far as lawyers are concerned. But sometimes, unfortunately, it is essential. But when we do go to court, people need to know that there is a funding there in place for them. So what do I say? I can come up with lots of nice quotes, but what do we need to do? We need to make legal aid as accessible to people as possible so that people do not have to fear going to preserve their rights or enforce their rights through a court. So that's it. Make it more accessible.
Thanks very much, Mark. And John, if you'd like to discuss the improvement of the human rights system here in Scotland, but may I prime you for that by saying that in the taxi I got over to Queen Street Station in Glasgow, the taxi driver asked me what I was going to do. I said, well, I'm going over to the Parliament to chair this debate, blah, 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 human rights. Don't talk to me about human rights. So, talk to me about human rights.
That was my dad. Ladies and gentlemen, I'm afraid I'm a bit confused now, having heard the other speakers, and I'd like to change my mind. I would like to urge you to vote for Brandon. I still don't really understand anything about arbitration and mediation, but I've rarely been so entertained while learning so little. And I got a text from security saying that we were to make sure to keep Brandon here while the Lothian Borders police make their way to arrest him for treason. I still can't believe that we actually saw that there, but it makes the day more interesting. I think whoever came up with the topic of how to improve the justice system was perhaps being too ambitious. For my part, I think it would be an improvement of sorts if we just stopped making it worse. And I do like Susan's idea of simplifying things. It would be nice if we had a period of 4 or 5 years where we didn't have any new laws and just took the time to understand the laws that we have properly. Because understanding the laws is an important part of it. And when I've mentioned myths about human rights, very often these come about because of a failure properly to understand or to explain what human rights are actually about. So that's why you have police officers who, when they've given the Kentucky Fried Chicken to the prisoner who's escaped from them and who's on the roof of a building, and they've said they had to do it because of human rights, that's just obviously quite simply wrong. So a better understanding of human rights would, I think, actually lead to an improvement in the law. There are, of course, some noble people, editors of tabloid newspapers, and some politicians who have been keen to warn us of the dangers involved in human rights. And it seems to be only every second month that we have a new commission set up to look into reviewing rights or abolishing them, coming up with a UK Bill of Rights to try and change it, people talking about opting out of Strasbourg. And that is, as I say, very good and noble of these people to warn us of the dangers, because there are obviously very, very bad things which happen in the name of human rights. So, for example, in Scotland, the abolition of slopping out for prisoners was, obviously, you would agree, a terrible thing. And I see that Dan Gunn's here. Terrible thing for society to abolish. Prisoners should require to continue slopping out. Prison officers should require to continue monitoring that and policing it. But because of human rights, we had to get rid of slopping out in Scotland, which we could have done at an earlier stage when we got warnings from various European bodies that it was unacceptable, but chose not to do that. Also, the right of access to a solicitor before or during an interview with the police. I don't know who any of you are, but I wonder if you could maybe take a straw poll. In Scotland, just within the past 2 years, the right to have access to a solicitor, to get legal advice before you were interviewed by the police, has been introduced. Hands up anyone who knew that until 2 years ago, there was no such right in Scotland. See, I shouldn't have asked the question then when there's so many people that knew about it, but I see there's quite a lot of government people here who were involved in making the change. But what's wrong with being allowed to have access to a solicitor? A lot of clients of mine and friends of mine and family thought this was a right that you had in Scotland anyway, but you didn't. You had it in England, and that's why some people picked up wrongly from seeing it on the bill that you could do it here, and you could also do it in America, where most of the films come from. So a vote for human rights would perhaps result in more of these bad things being abolished or ended, or rights being introduced to people that society doesn't like. But I think that would be a way of improving society.
Thank you. Before we open up the floor, I'm going to do a non-electronic vote. So you have to bear with me, and you have to behave. If I say, you know, put your hands up for number 1, number 2, put your hands up until I tell you to put them down again, until I've counted them, okay? Sorry, that sounded a bit more threatening than it meant to, but you know what I mean. What I'm going to do is I'm going to ask you to vote for either 1, 2, 3, or 4, and it's the 4 subject matter. So if your preference is for number 1, more arbitration and mediation, then when I say that, say number 1, more arbitration and mediation, put your hand up and I'll count you. And if your preference is 2, do the same. So don't put your hand up more than once and join in. Put your hand up on something. First of all, for number 1, who thinks that the best option is to look for more arbitration and mediation? Put your hands up now. Right. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. 18. Thank you. Hands down. If your preference is for making the law less legal, put your hand up now. Thank you. If your priority is improved access to justice through civil legal aid, put your hand up now. Thank you. And finally, if your priority is improvement on human rights, put your hand up now. Right, thank you. Right, my scoring for that is number 1, arbitration mediation, 18. Number 2, making the law less legal, 9. Number 3, improving civil legal aid access, 15. And human rights, 11. That's a very interesting set of numbers. And thank you all, you've done very well. Although, can I say to you that don't be so Scottish about it. A few people had hands like that, and I was struggling to see what was going on. Right, let me just, I've got some issues that I would like to hear discussed, but let me throw the discussion open. Who would like to ask a question or make a point? Yes, sorry, lady behind you, first of all, and then yourself.
I'd really like to endorse what Susan's talked about, really from
Right, thanks. Let me pick up a couple of those points and go to Brandon. This question of being adversarial, presumably in the arbitration and mediation world, we're trying to get away from that.
Well, certainly in the mediation world, that's absolutely right. I mean, the purpose of mediation is that parties try and negotiate a resolution, and they look beyond the direct dispute and try and find a way around it, try and find if there are other factors they can look at to increase the field of resolution, so there's creative ways to sort things out. There has to be that willingness there to negotiate in the first place. Arbitration is an adversarial process. You have got a third party imposing a decision, but because you are in private, that helps to calm things down. Because the decision maker might not necessarily be a lawyer, but might be someone who knows what you're talking about in that field, that can help calm things down. And because there is no actual requirement, you have a right, but there's no requirement to have a squad of lawyers on either side, that can calm things down. So it's got much more scalability than the court, which again can help calm things down. So I mean, probably more so mediation, but there are some things that mediation is going to be very difficult. And arbitration could be very difficult. Arbitration you can only really do if parties agree and contract. Things like matters of public right, freedom of information, status, that kind of thing, you can only arbitrate aspects of that. You can't really get to the meat of it. You've got to have a range of arrows in the quiver, I guess. And Mark, let me ask you, the question of, the hint I got was that sometimes there's a worry that the lawyers perhaps take over and run the case, now without suggesting that would be to increase fees and things, but sometimes there can be the danger of a mismatch between the lawyer's understanding of the case and where it might go and the client's buying into that or appreciation.
Yes, well, I don't obviously know the nature of the case that was being actually discussed here, but clearly any lawyer who is dealing with your case should be trying to explain to you in very simple terms what's actually going on. As a family lawyer, by very definition, that's what we need to do. But it's not to be lawyer-led. Clearly, it's client-led. Sometimes, depending on the nature of the subject, it can be a very difficult thing with a client. That client expectations sometimes and reality are very different things. And sometimes you do need to say, as forcefully as you can, I'm sorry, this isn't going to succeed, or we shouldn't go to court here. There's no need to go to court here, or you won't win if you go to court here. And there are times, of course, when clients sometimes don't like what you're saying. That's unfortunate, but that's what we do as lawyers here. So there we are.
At this point, I always tell my Frank Johnson story. It's a partner of yours, it's an old friend of mine who was in charge of bringing up trainees. And one of the trainees comes up and says, "Oh, Mr. Johnson, I don't think I'm cut out for this job. I can't tell clients bad news." And he says, "You're kidding, that's the best bit." Susan, this business of clients' expectations and understanding, your advice guide is absolutely fantastic. I use it all the time. I find it a very clear statement of areas of law, particularly areas of law I don't necessarily deal with all the time. Do you find that clients are still, as I used to find in the old days, slightly worried, terrified as to going to see solicitors?
Well, I think so. But I think part of the problem is sometimes what people, in our experience, what people want is they want the problem solved. That's what they want. They want the problem solved. And when you go to a solicitor, you will get potentially a legal solution. And that might not be solving your problem, which is actually where Brandon's mediation comes in, because that's what you want it to be resolved and gone away. And what we would argue for is the more information you have about what that problem is or where something's wrong, you would hope that you could address it early enough. If you address it early enough, it then doesn't escalate right up to needing court and needing lawyers. So that's why I think it's more important that you have, an expanded advice guide. Advice guide is still too simplistic. We want something with a bit more detail.
Suits me.
But to let you be informed, and to try and resolve something earlier and resolve your problem, not necessarily legally.
Yes, and another thing is the client must understand the process from the beginning. Of course, if you read my rather brilliant blog in the journal online about this very point, you've got to give the client what we would call a scope of engagement, letter as to what exactly is going to happen. Not just leave it with me, I'll be back in 6 months and you'll win. You've got to tell them what's what.
One of probably the the best professional experiences I had in recent years was a client who had been convicted in 2005 and had his conviction quashed on appeal. And he had been a teacher, never been in any trouble at all prior to his conviction. And he knew his case absolutely inside out, but he also knew a fair bit about the law, not all of it accurate, but accurate enough. And what it meant is that prior to his second trial in the matter, he was not prepared, as he had been in the first one, to sit back and say, my QC knows what he's doing, I'm just going to let him do it. So I was challenged every step of the way. We had some serious disagreements as we went along, but by the time of the trial, he understood, as far as he told me anyway, each of the decisions that had been made towards the conclusion of the case. And if he didn't always initially agree with them, he at least understood them, which was where we wanted to be.
All right, thanks. Sorry, the next question was this lady in front. You're looking round and you should be looking at me. Oh, they're getting the microphone. Thank goodness we've got a microphone. Yes, please.
I've got a sort of multi-headed question, really. For Susan, I would be very interested to know whether, in fact, any of your proposal was costed, and therefore what it might cost to the public purse, so that any benefit could be seen against that. And it's some years since Jane Ridley and Patrick Green of Resurrex came to give a lecture and debate, which was actually held within the Law Society premises, to extol the importance and, in a sense, flexibility and speed of mediation and dispute resolution. Since then, the number of people involved in this activity in Scotland have increased, but I would be very interested to know what the Society's view is on it now, and to what extent, as a profession, you promote it, because it seems to me it has so much to commend it.
What do you mean, promotion of the principle of mediation?
Mediation and dispute resolution, yes. Because it can be got to grips with perhaps before a thing escalates, before it becomes very much more costly if it's going to court, and the capacity for that temperature to be dropped and the thing to be resolved in a civilised manner.
Yes. If I can answer that, but
issues around children are concerned.
Yeah, if I can answer that, but first of all, before passing over to Susan, the Society it has a statutory function in doing whatever is in the best interests of the people of Scotland. It's a kind of no-brainer. There is no doubt that a quicker or less slow, less costly, more cooperative or collaborative outcome to any matter is going to be in the best interests of one's own client and the population at large. So I don't think I don't think I'm going to argue back that somehow we should be heading for litigation and conflict first. So as one or more of the panel said, it's a last resort. Susan.
Okay, in terms of costings, I mean, I think one of my key things was actually when a statute is made is you need to write a translation of it. And I don't think the cost of doing that should be too prohibitive. I mean, most statutes coming through Scottish Parliament are accompanied by a policy document to try and explain the intention. So it would be, for me, it would be a simpler version of that explains what is meant. I think the costs come then when we're trying to disseminate that information. But I think if you disseminated that earlier, it would be preventative spend, because I would hope that by doing that, you would avoid it further down the line and address the cost of what Mark was saying. I would hope.
That preventive spend needs to be quantified to get it in the public realm for the public to understand.
Difficult to quantify. Difficult to quantify what you're preventing.
Well, you might say the underlying principle of educating and informing the public about the law to which they're subject is beyond all price. There were two hands at the back. The lady on my right.
Because I feel it's a bit of a fallacy that if we go to arbitration, we're going to avoid costs, and any costs will be absorbed. Any costs absorbed will be kind of like limited by the fact that we're all sitting around the table and there's lawyers there, and it's less confrontational. In fact, this will grow a nice new industry for people who want to specialise in arbitration, because there's going to be less money wasted and things. With my experience, and I've gone through a period of protracted arbitration where there was a dispute, and it actually lasted from 1998 to 2005. So this idea that there's less money spent, it saves money, etc., is just an absolute fallacy, because whatever somebody or the parties involved in a dispute have, they will spend. So what you do find happens, in fact, in reality, is that it just goes on and on and on, because whatever decision is made by an arbitrator can be overturned. So it just is one of these perpetual sort of cycles that carries on and on and on. And the only people that really do benefit from it at the end are the people who are meant to be, the professionals. So that whether they get the money through the court system or they get the money through, sitting around a table is by and by. And my second point is actually to Mark. You're arguing for more legal aid for people. And that's obviously very laudable, because some people can't actually afford the process of going to court or to get involved in legal disputes, or to be perhaps, if it's criminal defence, or actually, having to defend themselves. And my question is this, to the panel in general: do you think people get a better service if they're a private client or if they're actually a public funded client through the legal aid system? Because my experience is the latter, actually.
Can we deal with that point first, and then we'll come back to the arbitration point? Mark?
Yes, I'm probably one of these sad lawyers that are out there that treat all clients exactly the same. And I do, and that's what happens. So if you come through my door, it doesn't matter whether you're paying or whether you're not. I can't speak for other people. It is a sad fact of currently where we are in terms of practice in Scotland, that there are many, many firms in Scotland who simply do not do legal aid work. There are less and less firms in the big cities, and there are less firms probably doing it around Scotland. Now, what you're getting there is you are getting in the firms that do it an area of specialisation. But certainly as far as I'm concerned, there is no difference between the private paying client and the legal aid client.
Okay, John, your clients, by and large, will be legally aided.
The vast majority of my clients are legally aided, and I don't see another way of doing the job apart from doing it exactly the same for them as for the fee-paying clients, of whom there are obviously relatively few. Some of my most demanding clients who have challenged me and wanted to know what's been going on every stage of the process, or phoning every day, have been clients who have been legally aided, and a lot of that you're not paid for, but it's part of the service you're providing to them. So I certainly don't make any distinction, and no one in my firm does.
I suppose there may be an element, I'm just thinking out loud, that where somebody is legally aided and you're required to get in specialist reports, whether it be medical reports or other technical reports, there can be delays in getting those because you're required to get funding from the legal aid board to get them, whereas a privately paying client might have the money up front. That's not the solicitor's fault, that's perhaps the fault of the system. Coming back to the arbitration point, Brandon, arbitrations that go on forever? Sure.
I'm very sorry to hear you've had that bad experience. Well, indeed, I'm sure it was a stern lesson, but what I can say is that would have been under the old common law system of arbitration we had in Scotland, and arbitration more or less died a death in Scotland because of problems like that. And this problem was identified, and we have, since 2010, a new Arbitration Act that tries to stave off a lot of these problems. If you look at Section 1 of the Act, it says that the founding principles of this Act are that the object of arbitration is to resolve disputes fairly, impartially, and without unnecessary delay or expense. So the emphasis now is very much on pushing this through within a time scale which is comparable to, and we would hope, shorter than a court action. And what you have with arbitration is you have a great degree of flexibility, so that you don't need to have the formality of the pleadings and what have you. Now, that is what arbitration used to be, except that in years gone by, it was very much a replication of court session procedure, but probably even worse, because there wasn't the same pressure of court time and a judge pushing it on. Things are very different now. We're promoting something which is not the experience you're talking about. In your particular case, you've obviously had a bad experience. But as I say, I don't know what the subject matter was or the scale of that was. But I mean, certainly, if you have obviously if you have a major multi-million-pound complex dispute, then it's entirely proportionate for the thing to last quite a long time, for there to be lots of lawyers involved, and for the expense to be high, because there's a lot at stake and it has to be dealt with in minute detail. What I said was an advantage of arbitration is that scalability. So if what you have is a small-scale dispute between private individuals, then it ought to be dealt with by someone who has knowledge of that subject matter in a focused way, in a quick way, and parties are not compelled to have a solicitor represent them in arbitration. So that's an option they have. and it may be possible, therefore, to resolve it in a much more cost-effective way if we're dealing with that sort of small-scale dispute. Now, there'll always be the middle ground. There will always be the dispute that grows arms and legs and becomes much more complex and gets delay. But there are other options and alternatives, and within the Act, there are things like the ability to cap the recoverable expense, to cap the spend, which perhaps addresses the issue you're talking about of an imbalance of power and one party having a lot of money and the other party not, and the one party simply being able to outspend the other. This is not the forum, it's not the time to get into the detail of the new arbitration regime, but what I would say is that since this has come in 2010, we have a world-beating system which can be scaled up to the major international disputes, but also scaled right down to the small-scale disputes so that they can be dealt with in a way which is much more in proportion to the amount in dispute.
Thanks for that. Let's fire through some more questions. The gentleman at the back who had his hand up a minute ago. So, no, don't worry. I'm working my way around. There's lots of hands up.
2 points I would like to make. One, making the law work, I think, definitely needs investing in education. So my question is, how much law is taught in schools, and mainly in secondary schools? And what's the place of law in school curricula? Because I think that there is ignorance of law at this stage. So prevention is better than applicability. My second point is how much cultural diversity is taken into account in law-making process and in law applicability, especially we know now that we live in a global world, and culture is very important. What might be right for someone, for a country, might be sometimes misinterpreted in another country. Thank you.
Thank you for that. In fact, a couple of years ago, in this very chamber, we had this session on law as an educational tool, if you like, the business of educating school students and the general public. We'll come back to that. I'm just going to go through some more questions. But I'll come to you next, madam.
I don't need a microphone. It's okay.
Well, maybe the people at the back might not hear you.
All right. My name is Debbie Williams. I came to Scotland in 2004. I originally from Taipei, Taiwan, and when I came, I was a very fit and successful businesswoman involved in property investment. And so I have a quite eventful life in Scotland since 2004 to 2012. So I have a chance to access, to hire a legal lawyers as a private client, and also because I have a very eventful life, so I also be able to access the legal aid because when I was ill. But what I'm saying is, I'm not going to ask questions, but I'm going to represent some facts, okay? And from my experience, to whether it's being a private client or the legal aid client, you wouldn't get. It's no guarantee you will get the adequate service from the Scottish lawyers and law firm. And also I want to say is 2004 and to 2007, I sold a lot of properties, but because some people jealous about my success, so I was assaulted by the doctor and nurse and the police. However, I went through the 3 criminal lawyers, and none of them to challenge that and the defense for me in the court. And the one of the criminal lawyer, defense lawyer, was trained by the John Scott QC law firm for 6 years. He didn't challenge the police evidence.
I don't want to talk about specific cases.
Okay.
I want to talk about general principles,
okay.
Please.
General principle is, I actually, because I experienced 3 criminal lawyers didn't defend my case, so I took it to the Law Society. Fortunately, I built out a law society twice, in 2009 and 2011, and also the Russell Aiken solicitor. And then the third time, I should build out a law society as well, but the third time, the Law Society and the Scottish Legal Complaint Commission, they work together to minimize my complaint.
We can't really deal with
yes,
your,
but
you keep coming back to your own
saying
case.
is because those lawyers issue the license through your organization, you don't have a policy, you don't have any discipline to make sure the lawyers, they register with the Law Society, you charge them 600, 700, pounds a year, but you don't protect the public when we try to use, the service and we pay the money away through legal aid system. And also, I don't dispute we should get the legal aid, as easy as possible. However, the two things we should consider. One thing is the legal aid board. No, wait a moment, let me finish. Well, what I'm saying is, what's wrong with you? No, okay, let me finish. The legal aid board, they concerned about, because the many lawyers, they manipulate the systems. So that
I think your probably point is trying to just denigrate generally the Scottish legal system, legal aid board, I guess, Law Society. I don't think we have the time to go into this in detail because you're talking about your own case. We must move on with general principles.
Okay. I'm talking about my experience to access legal aid and the solicitors in Scotland for several years.
Well, they're not here to answer for themselves, so therefore we do have to move on. I'm sorry, you have made your point. You're dissatisfied with the Scottish legal system, but we don't have time to look at that in detail.
How to train those solicitors to be qualified lawyers.
I think there's a very detailed training program for solicitors. Right, some other people had hands up over here in the corner. John.
Hi, my name is John Forsyth. I pulled together the weekly legal section of the Scotsman on a Monday, if anybody wants to. Has a spare quid next Monday. I'm not a lawyer. I think there's an old joke about what you call somebody who hangs around with musicians. The answer is a drummer. I'm a kind of legal drummer. I mostly know about the law according to what's in next week's paper. It's all getting a bit vague by last week's paper. But I can offer Sue one piece of free legal advice, which is that the expression guide for dummies is a trademarked expression, and I can save you a lot of money from any of the other people on the panel by saying Wiley and Company of the United States will be on your back as soon as you say it again. I think the broader point, and I didn't vote for any of you, by the way, because I'm hoping that there's 4 commissions for future articles around the front of the table. But I think the question that I would like to ask all of you is that, and John did touch on it, but would we all be better served really if lawyers spent more time talking to legislators about the attractions of legislative celibacy?
All right, let's just go around the panel. Brandon, you start.
I don't think celibacy fits in with my talk, but
Posting again.
Well, I mean, I think John made the point. If we had no legislation for 5 years, then no doubt we could get to grips with what we've got. But I don't necessarily agree with that. I mean, we've had a long period in Scotland where we didn't have the focus on our legal system. We didn't have the reform we needed because we didn't have our own parliament. We've had a period since the devolution's come in focused on things that needed urgent attention and things, in fairness, which were, coming back to my lecture, politically sexy, the things that grab the headlines, the things that do interest the general public, perhaps slightly less than the things that actually needed done. We then had the minority government for a while, and we managed to get through some things which everyone could agree were good things, like the Arbitration Act. Now, the arbitration law in Scotland has been a mess since, well, forever, more or less. We have legislation on the books from 1695. So the fact we've had this Scottish Parliament and we've been able to focus on these areas and implement areas where we know there's a need for reform and improvement of the law, I think that's been a good thing, and I think there are still a lot of areas where the law needs to be looked at and reformed and simplified and brought up to date and brought into line with global best practice. So I guess I'm saying I'm against celibacy. Is that?
We'll take it as that. Susan, do you think that in our rush to whether it's legislating on the hoof or in response to social things that come up, do you think the law is getting more complicated rather than there being a kind of a level of comprehension or a level of clarity that I think used to be in some of the old-fashioned laws and statutes? Do you think as life gets more technical, the law gets more technical?
I think it does. I mean, I think certainly employment law is a case in point, I think, which has become far more complicated. But I would probably not agree with stopping all laws, actually. I think laws are supposed to represent the society. They're supposed to respond to society's needs. My argument is that they're not really written for people, and yet we are the society. And so I think we need to start again in terms of how we write them and how we communicate them.
So it's not the substance, it's the presentation, in other words. John, the law, certainly around about criminal representation, human rights, is developing, and there is legislation both coming in and about to, and going to come in. What's your view of that?
Well, in general terms, I mean, I think the Scottish Parliament has produced some excellent legislation, and thinking in particular, for example, of adults with incapacity legislation, which is world-leading and incorporates a proper appreciation of human rights as an example for others. But there is still too much reaction to things. We don't, I think, take the time to look ahead and see what's coming, although Lord Carloway in his review suggested that we should do that to avoid the Cadder-type situation where a single court decision causes all sorts of disruption. But even then, the emergency legislation that followed that went much further than it needed to. I think that's widely recognised, at least out with the government.
And do you think the legislatures didn't listen to the lawyers?
They didn't. Well, I think they didn't speak to them, and certainly didn't speak to them or listen to them carefully enough. The legislation went through in a short number of days, and the Human Rights Commission was ignored, which was, I think, a particularly bad example to set so far as an approach to human rights generally is concerned. But on the criminal justice side, there's still far too much legislation. The Criminal Justice and Licensing Scotland Act 2010, I started reading it in 2010 and I haven't finished it yet. If I haven't read it all and understood it, then it's going to be very difficult for me to explain it to my clients.
Yeah, good point. And Mark, my version of the question for you is, does civil legal aid provision keep up with what seems to be the increasing complexity of legislation and the civil law?
Yes, well, I can give one example. We recently had the Family Law Scotland Act 2006, which brought in the right of cohabitants, something akin to married people when they separated. Of course, by-the-ins, as they used to be. The trouble is, as soon as we legislate for that, we open up a whole raft of cases. And of course, the law is the law, but the law has not been interpreted, and the law can only be interpreted by the courts. And thereby, we have then a raft more of cases coming before the courts, all to be interpreted, and in which, of course, legal aid is being sought for. So every piece of legislation that comes through the court has the knock-on effect in terms of the interpretation. And we as lawyers don't know all the answers. We see a piece of legislation, we can read a piece of legislation, we can interpret that piece of legislation as we wish to interpret it, but that's not necessarily the interpretation of other people or indeed the courts. I should say in passing that I think I've been quoted this, and so forgive me if I'm entirely wrong about this, but somebody once told me that the Swiss Parliament sits twice a year to legislate for the whole of that year. I suspect we're doing a little bit more legislating than that.
Gosh, yes. Now, we've just about last. Is that a comment? Right, observation, because we don't have time for answers. Fire away.
Thank you. Joyce Nicholl, I was very surprised by John's modesty on the human rights. It very much is the overarching principle that sets the boundaries both for interpretation and in decision-making, including through the legislative process. And all of the issues that have been raised today very much sit within that. And my concern is we've not looked at what will be the effect should Scotland go into independence, both on a statutory basis and on a legal basis, of human rights, and we really need to be looking at that. And we must allow ourselves to be open to critique and to review, including by this lady here. And one of the pieces of jigsaw missing within our legal system, as I see it today, is a proper representation of party litigants and of the experience of party litigants throughout the process, and that ties in very much, Susan, with what you were saying and various other things. And if a body akin to the Law Society of Scotland was put into place for party litigants and was part of the Rules Council, for example, I think a lot of the difficulties that we've been seeing could be reduced.
Thanks very much for that. And unfortunately, we have run right out of time. There are a lot of issues arising out of that very set of observations. One thing I will say is that in terms of independence, I was one of Mike Russell's kangaroo court the other day when we were looking at some of the legal issues arising out of the current situation and the forthcoming referendum on independence. There's so much kind of happening. It's our job as a society to make sure that that comes out, and our Director of Communications is here, Kevin Lang is here, and please look at our website, look at the anything that comes out from the Law Society of Scotland, because there's a huge amount of information on these and other topics. Anyway, just about time to wrap up. But before we do, let me take my second vote to see if anybody's mind has been changed. So again, the old-fashioned system. For those who think that priority is more arbitration and mediation, hands up now. Right. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Thank you.
I think I lost a couple of my voters. I don't know.
On making the law less legal, hands up now. I know it's a secret ballot, but the head of Scottish Government's legal services putting his hands up for making the law less legal is an interesting one. Improved access to justice through civil legal aid. Hands up, please. And finally, improvement in human rights. Hands up, please. Thank you. Well, very interesting results. And it's a tie. Number 1, more arbitration mediation, 15. Making the law less legal, 11. Improved access to justice through legal aid, 12. And human rights improvement, 15. So, yes, give yourselves a round of applause. Can I finish off by thanking our expert panellists for their contributions, and to you, our audience, for helping make this a thoroughly interesting and thought-provoking event. Also thanks to the Scottish Parliament team for their support in the organisation of the event, and our own Law Society officials for their organisation. The event has been filmed, and for anyone who wants to view it again or wants to share it with colleagues or friends, then it will be available on the Law Society's website in the coming weeks, as I said, as will everything else that we've talked about one way or another. One very final thing, Law Society will be holding its annual conference in Glasgow on the 17th and 18th of September, which is open to all members as well as non-members of the Society. This year, the programme will cover a range of issues facing modern law firms, including the challenges and opportunities of future business structures, as well as discussions on the Scotland Act, independence, and the rule of law. Two of our keynote speakers are Tim Harford, the undercover economist, and Roger Flynn, experienced CEO director of 5 global companies across multiple industries. More details available again on our website and through our Twitter handle. So do follow follow the. I don't do Twitter, so I'm going to stop now. Follow whatever it is you do on Twitter to get updates from the Society. But thank you very much and good afternoon.